Welcome to the lecture number 5 in Sale of Goods Act in the CA Foundation lecture series sponsored by Sri Jendra Rank Zone. I am your mentor Shekhar Gehlot. In this unit we are going to discuss about implied conditions. We'll go further on implied conditions, like we have done express conditions and what can happen upon the breach of such conditions. Now we'll deal with implied conditions. We have understood what are implied conditions. Implied conditions are conditions which law assumes to be present in every contract of sale of goods, whether it is mentioned in the contract or not, but law will assume that these conditions were present. Okay, what are those conditions? Let us have a broad look first, then we'll discuss them in detail. Conditions as to title, okay, condition as to description, condition as to title, condition as to description, condition as to sale by sample, condition as to sale by sample as well as description, condition as to quality or fitness, okay, condition as to quality or fitness, condition as to merchantability or merchantability, whatever way you call it, condition as to merchantability, condition as to wholesomeness. Give it a look and then we will go for a detailed discussion over what are these implied conditions. Now the first condition is condition as to title. Condition as to title. Title word itself means ownership. Title means ownership. Okay, title means ownership. Now let's read it. In every contract of sale, unless there is an agreement to the contrary, unless there is an agreement, okay, till the time you do not have another separate set of agreement which says that this condition should not be understood as part of this contract. Till the time you do not have a written agreement against this, this condition is to be presumed to be present in every sale of contract. Okay. The first implied condition on the part of the seller is that this is the first implied condition on part of every contract of sale on the seller. Okay, these conditions are implied upon seller, not on buyer. Okay, conditions are implied upon seller and not on buyer. In case of a sale, he has a right to sell the goods. Okay, condition is a title, that means he has a right to sell the goods. So when he is selling goods to us, he has a right to sell, he has an authority to sell. It means goods should not be okay, it means good should not be a stolen good or a misappropriated good. I go to buy a watch, a Titan watch. at a showroom. They sell me a watch which is a stolen piece. Okay, which is a stolen piece. Now I claim a refund. I want to return their product, but they say this is not mentioned in our contract that Titan watch has to be does not have to be a stolen watch. I say no, law presumes it. Even if you have not written it, law presumes it. So when you sell me a Titan watch, that means you had a right to sell that Titan watch, meaning thereby the watch should not be a stolen good, okay, or a misappropriated good. Misappropriated good means, let's take the example of Muthoot Finance. Okay, someone has pledged his gold, someone has kept his gold jewelry to Muthoot Finance. Okay, and he is paying his installment, but still, without his prior permission, Muthoot Finance sells this gold to someone else. Muthoot Finance has sold this gold to someone else even before the expiry of the contract with that gold person. Now, that is called a misappropriation. Gold by Muthoot Finance MF. Okay, misappropriation of gold by Muthoot Finance. So Muthoot Finance should not do that. So whenever I buy a gold from Muthoot, it is an implied condition that Muthoot Finance has the authority and the right to sell that gold to me. Otherwise, that will be presumed as a breach of implied condition as to title. In case of an agreement to sell, he will have right to sell the goods at the time when the property is to pass, or in the case of agreement to sell, that whenever on future date he will sell me those goods, he will supply me those goods, on that date he would have acquired the right to sell those goods. He would have acquired the right to sell those goods. Let's, in simple words, the condition implied is that the seller has the right to sell the goods at the time when the property is to pass. If seller's title turns out to be defective, if the seller's title is defective, that means seller has no authority or seller is selling them as a stolen goods or misappropriated goods. Okay, I am a housekeeper. I'm a housekeeper and the house owner has a car which is standing in the house. Now I deal in the car, I sell the car. I have no authority that, okay, so my title was defective. My title was defective. If the seller's title turns out to be defective, the buyer must return the goods to the true owner and recover the price from the seller. Now, in this case, what will happen? The buyer is duty bound to return the goods to the owner. I will return the good to the owner now. I will not return the good to the seller, but I'll claim back the price from seller. Okay, I'll claim back the price from seller only, not from the owner. Okay, not from the owner. So if tomorrow seller has used those funds and now seller says I do not have any money, you take me to jail or do whatever you want to. Now my money is gone. I cannot claim the property, claim the money from the owner. I cannot say that I'll not return the car till the time my money is not paid. No owner can take it anytime from me because my title is defective as I purchased it from a person his own title was defective. So a person with defective title cannot sell the property, cannot deliver a fair title to someone else. Okay. Example, let's do an example. A purchased a tractor from B, who had no title to it. Okay, who had no title to it. After 2 months, the true owner spotted the tractor and demanded it from A. Held that A was bound to hand over the tractor to its true owner and that A could sue B, the seller without title, for the recovery of the purchase price. Okay, now in this case, A, because he has a stolen tractor or a misappropriated tractor, now he must return it back to the owner upon the demand of the owner, and he can claim the price back from the seller, that is B, but he cannot claim the price from the tractor owner. If A sells to B tins of condensed milk labeled CDF brand, okay. If A sells to B tins of condensed milk labeled as CDF brand, and that is proved to be an infringement of N's company's trademark, okay. it will be a breach of implied condition that A had the right to sell. B in such case will be entitled to reject the goods or take off the label and claim damages for the reduced value. If the seller has no title and the buyer has to make over the goods to the true owner, he will be entitled to refund the price. Okay. So I I bought a Kia car. Okay, later on found Kia that the car is a copy of Kia car. Okay, car is a copy of Kia car and not a Kia car at all. So now in this case, this is an infringement of the copyright or the trademark of the Kia. Okay, not copyright but the trademark, because Kia has a trademark and only Kia has the right to sell Kia cars. If someone else is selling Kia cars without authorization, he's manufacturing his own cars, putting the label of Kia there, then the car is defective. I must either use the car after removing the Kia label from it and seek compensation from that guy, or I can return the car as a whole and seek refund of the price. Okay, I can treat it as a breach of warranty, as well as if I want, I can treat it as a breach of condition and seek a refund as well. Sale by description. Okay, sale by description. What is description? See, if I have to describe someone, okay, I'll describe. Suppose I have to describe a car, I'll describe the car as an SUV, 5-seater, 50 liter, 50-liter tank, 220 km per hour speed, white color, okay, so on, okay, so on, engine capacity and all. Now, if someone has sold me by description, where there is a contract of sale of goods by description, like someone is selling me by describing it. Okay, he had described me what kind of car is he going to sell me, like an SUV. He's going to sell me an SUV which has a 5 seating capacity. It has a 50 liter of fuel tank. Has a top speed of 220 km per hour. It has a white color. Okay, there is, and now there is an implied condition that the goods shall correspond with the description, that the car which he is ultimately selling to me must correspond to this particular description which he has given to me, which the seller has given to me. If the seller has given the wrong description, then that will be treated as a breach of implied condition. Okay, this rule is based on the principle that if you contract to sell peas, you cannot compel the buyer to take beans. Okay, if someone says, this is the rule, that someone says I'll sell you peas, then he cannot sell me beans. Okay, they both look similar, but definitely they are different. The buyer is not bound to accept and pay for the goods which are not in accordance with the description of the goods, which are not. So buyer is not bound to accept the goods. He can reject the delivery and claim a refund if such is the case. Thus, it has to be determined whether the buyer has undertaken to purchase the goods by the description, whether the description was essential for identifying the goods. Now, these are the determinations which a court has to find out whether he was actually deceived, whether he was actually compelled to buy the car by a description. Okay, like suppose I go to a car showroom. Okay, I go to the car showroom. The car seller says I do not have the car ready right now in my showroom to you for you to have a display of it for you to have physically inspect the car, but I can give you the brochure. He gives in the brochure, and brochure describes the car, and I see the car as the brochure, and then I purchase it. It turns out to be something else. Okay, this is the case of sale by description. Then court will have to determine whether I went by the brochure or I had the option of physical inspection, whether the description was essential for identifying the goods where the buyer had agreed to purchase. Okay, whether the description was essential. If that is required and goods standard do not correspond with that description, it would be a breach of condition entitling the buyer to reject goods. If description was essential, and if I bought the car only on the description and it turns out that the car does not correspond to the description, then I am entitled to reject the goods and claim a refund. I am entitled to claim a refund. It is a condition which goes to the root of the contract. Okay, it goes to the root of the contract. That means it uproots the contract. Okay, it damages the root of the contract. It damages the basic foundation of the contract. So when the foundation or when the root is damaged, okay, when the root is damaged or the foundation is damaged, then upper structure cannot stand. So other part of the contract cannot stand when the root or the foundation of the contract is itself damaged, and the breach of its entitles the buyer to reject the goods whether the buyer is able to inspect them or not. Whether the buyer is able to inspect them or not, it's immaterial. Okay, let's do an example. A at Kolkata sells to be 12 bags of waste silk. 12 bags of what? 12 bags of waste silk on its way from Murshidabad to Kolkata. There is an implied condition that silk shall be such as is known in the market as waste silk. If it is not, B is entitled to reject the goods. Okay, so if someone is saying it's waste silk or it is raw silk, okay, it is waste silk or raw silk, then it should actually be the waste silk or raw silk which is available in the market. Okay, it should actually be the waste or raw silk. If it is not, then this is a sale by description and implied condition is breached. Okay, a ship was contracted to be sold as copper fastened vessel, but actually it was only partly copper fastened, held that goods did not correspond to description and hence could be returned, or if the buyer took the goods he could claim damages for the breach. Okay, someone sold the ship as fastened by the copper and it was partly fastened by the copper and partly by the iron. Now ship is in the marinated conditions all the time. Ship is in the water, that too saline water. So if fasteners are made of iron, they will rust out and ship will wreck out. Ship will have to undergo a serious maintenance, so that is why copper is preferred. But if you sell a partly copper fastened ship as a copper fastened ship, okay, then that is a breach of implied condition in the as sale by description, and the buyer can reject the ship and seek a refund. The act, however, does not define description. Act, however, does not define what is the description. Okay, it says sale by description, but does not define description. It will depend on case to case basis. Okay, a sale has been deemed to be by description. In following cases, sale has been deemed to be sale by description. Okay, where the class or kind to which the goods belong has been specified. Okay, where the class or the kind has been specified, like Egyptian cotton, Java sugar, Sheffield crockery, etc., Bon China, like this, or Banaras silk, or Tiruvananthapuram silk. Okay, Banaras sari or Trivandrum silk or Tiruvananthapuram silk. Then This is a sale by description. It is a sale by description. Where the goods have been described by certain characteristics essential to their identification. Okay, goods was described by certain characteristics which were essential for their identification, like jute bales of specified shipment. Okay, jute bales of specified shipments, jute bales of shipment coming on that date, shipment number is so and so. Okay, steel of specific dimensions, steel of 18-inch thick steel. It may be noted that description in these cases assumes that form of a statement or representation as regards to identity of a particular goods by reference to the place of origin or mode of packing, etc. Whether or not such statement or representation is essential to the identity of goods is a question of fact depending in each case on the construction of the contract. So now whether the sale by description is actually a sale by description or not, okay, it depends upon the case to case basis. That is left to the court will determine whether the sale was actually a sale by description. If it was a sale by description, then if it does not correspond to the description, then you can seek the refund and return the article. But if it was not a sale by description, a description was only given upon us, but it was not a sale by description. Okay, description was only a passing remark, then you cannot treat this as a breach of condition of sale by description. It will depend on case to case basis. Sale by sample. Okay, sale by sample. In contract of sale by sample, there is an implied condition. That what is the implied condition in sale by sample? What is sale by sample? In sale by sample, a small portion or small part of the product is shown. Like if I want to buy high grade silk, they show me a small piece of cloth, okay, that this is high grade silk and we'll sell you this kind of silk. Or I want to buy basmati rice, they show me a handful of basmati rice, a fistful of basmati rice to inspect, and they say the larger consignment will be corresponding to this sample. This is the actual sample of the larger bulk. Now, the conditions are that when the sample is shown, the conditions the law imposes are the bulk shall correspond with the sample in quality. Okay, the quality of the sample shall be same as the quality of the bulk. It cannot be the case that what is shown is different and what is delivered is different. Okay, it cannot be that sample was of basmati rice but bulk was of raw rice. Okay, it cannot be the case. The buyer shall have a reasonable opportunity of comparing the bulk with the sample. Additionally, you will also provide a reasonable opportunity to the buyer to inspect the bulk. Okay, to inspect the bulk with the sample. Now you are giving sample and you should provide reasonable opportunity to the buyer to come and inspect the bulk quantity as well. In case of sale by sample of two parcels of wheat, the seller allowed the buyer an inspection of the smaller parcel but not of the larger parcel. In this case, it was held that the buyer was entitled to refuse to take any latent of the parcels of wheat. He was entitled not to take the other parcel of the wheat, okay, which was not shown to him as it did not correspond to the sample. The other condition in the sale by sample only is the goods shall be free from any defect rendering them unmerchantable, which would not be apparent on the reasonable examination of sample. Goods should not have such condition which render them unmerchantable, unusable, or unsellable in the market. And this defect should not be hidden. Okay, this should not be such a defect which could not be found out by a reasonable examination. If it is a defect which can be found out by the reasonable examination, okay, then the fault will be of the buyer. If the defect is such that even after reasonable examination, buyer could not have understood, buyer could not have found out the defect is so craftfully hidden by the seller, then that shall be a breach of the condition of sale by sample. This condition is applicable only with regard to defects which could not be discovered by an ordinary examination of the goods. But if the defects are latent, then the buyer can avoid contract. Latent means hidden. Latent is hidden. A company sold certain shoes made of special sole by sale for the French army. Okay, a company sold certain shoes made of special sole by sample for French army. The shoes were found to contain paper not discoverable by the ordinary inspection held. The buyer was entitled to refund the price plus damage. Okay, buyer was entitled to refund the price plus entitled to seek the damages as well, because the sole contained a paper which was not discovered, which was not discoverable by normal inspection. It was only to be found out after the actual user of the shoes and after some wear and tear of the shoes, not before that. Sale by sample as well as by description. Okay, when you are selling by sample as well as description, where the goods are sold by sample as well as by description, the implied condition is that the bulk of goods supplied shall correspond both with the sample and the description. Where the goods are sold by sample as well as by description, the implied condition is that bulk of goods supplied shall be correspond with both sample as well as whatever description you have given. In case the goods correspond with the sample but do not tally with the description or vice versa, both the buyer both the buyer can repudiate the contract. Okay, buyer can repudiate the contract. A agreed with B to sell certain oil described as refined sunflower oil. Okay, warranted only equal to sample. The goods standard were equal to sample but contained a mixture of hemp oil. B can reject the goods. Okay, now he showed the sample. Sample is same as of the bulk, but the sample is also defective. He is showing it as a sunflower oil, but sunflower it is not a sunflower oil. It is a mixture of hemp oil and sunflower oil. So he can now reject, because in this case he is selling by sample as well as by the description. Now the goods correspond to the sample, but they do not correspond to the description. Conditions as to quality or fitness. Ordinarily, there is no implied condition as to quality or fitness of the goods sold for any particular purpose. Usually, there is no guarantee. Okay, that we are giving you a car, it shall not meet the accident. It will be able to take you to the highest mountain available in the world, or this and that. It can drive in the sun, a wet road, it can drive on the off road, it can drive on the snow conditions. No, usually these are not found to be conditions. Okay, drivability is the only condition, but not the manner or the way you want to drive it. Okay, but sometimes, however, the condition has to reasonable fitness of goods. Okay, reasonable fitness of the good. A car should be drivable enough. Okay, it's okay, you cannot take it on the mountain, or you cannot load it with extra weight, or you cannot drive it for off-roading, but at least it should be able to drive on the regular road. It should be drivable. That is the reasonable fitness we expect from a car. Okay, however, the condition as to reasonable fitness of goods for a particular purpose may be implied if the buyer had made known to seller the purpose for his purchase and relied upon the skill and judgment of the seller to select the best goods, and the seller has ordinarily been dealing in those goods. Even this implied condition will not apply if the goods have been sold under a trademark or a patent name. Now, usually the fitness or the quality are never a implied condition. Okay, because they depend upon the user. If you are using something nicely, definitely it will behave nicely. If you are using a machine in a very rough manner, it will become a rough machine. So you cannot later on run after the seller and say that I used it as a rough, but it should remain as a refined condition. No, that can't be the case. But however, the implied condition for quality of fitness may become a part of the contract when you are when you reach approach the seller for a specific good. Okay, when you approach the seller for a specific machine, specific good, and seller is ordinarily dealing in those goods. Okay, and on the advice of seller you purchase something. Okay, on the advice of seller you purchase something, like I asked a seller that you supply me a good racing bike, a good racing bike, and he is a bike seller and he is an expert. He supplied me an ordinary bike. Okay, he has given me a bike. Bike can run fast as well, but bike is not suitable for racing purposes. I wanted a racing bike. I am a bike racer. Okay, I am a bike racer, but he has given me a bike which is not suitable for racing, but very good in driving, other very good in riding otherwise on the roads. No, I do not need a bike like that, and I relied upon his expertise. So the bike is not having the required quality or the fitness as per my demand. So in this case, this is a breach of implied warranty. Even this implied condition will not apply if goods have been sold under a trademark or patent name. But this implied condition will not be there if seller has nothing to do with it and seller supplied me just a good brand. Okay, a good brand, and the good brand did not function. Now the seller is not liable for that. Suppose there is a brand which says we are a racing brand, we manufacture racing bikes, our bikes are known for our racing capabilities. It's a well known brand, and he supplied me that brand motorcycle. His job is done. Okay, now it is, if there is any default, then you should rectify it with the company. Seller is not liable. Okay, because he has supplied you a branded or a trademarked or a patented product. Okay, which is well known for its racing capacities, but somehow you have got a product which is not fit as per your expectations. Now there is no wrong on the part of the seller. If you have any issue, you can definitely check in with the company, but not with the seller. A went to B's shop and asked for a Merit sewing machine. Merit sewing machine. B gave A the same, and A paid the price. A relied on the trade name of the machine rather than on the skill and judgment of the seller. B. In this case, there is no implied condition as to fitness of the machine for buyer's particular purpose. Okay, because first of all, he has himself asked for a particular product, and he is not relying on the judgment of the seller. He is going by the brand, and if the brand is not as per the expectation, then seller has no responsibility here. Seller is not bound to refund or to compensate you. Okay, it won't be treated even as a breach of warranty. Forget about breach of condition. As a general rule, it is the duty of buyer to examine the goods thoroughly before he buys them, in order to satisfy himself that the goods will be suitable for his purpose for which he is buying them. This is known as the rule of caveat emptor, which means let the buyer be aware. This is the general rule of caveat emptor. Usually, a buyer is duty bound to make a small research or make a detailed research about the product he is going to buy, and then he should also inspect the product, and after his own satisfaction, then only he should buy it. He should not rely upon someone else's opinion and then cry foul over it. He is duty bound. Condition as to merchantability, section 16.2. Condition as to merchantability. Merchantability means reselling, transportable, usable, etc. Where goods are bought by description from a seller who deals in goods of that description, whether he is the manufacturer or producer or not, whether he is the manufacturer or he is a producer or he is simply a dealer. Okay, there is an implied condition that the goods shall be of a merchantable quality. That the goods shall be of a merchantable quality. Merchantable quality depends upon what is the merchantable quality depends upon the goods. Like, okay, like if I buy a laptop, forget about the sturdiness or the quality or the hardness or the durability of the laptop, but at least it should be capable of performing basic functions of a laptop. Okay, it should be able to perform basic functions of laptop. Now, even if it does not perform the basic functions of the laptop, that means the laptop is not a of merchantable quality. It is not usable. It's not of merchantable quality. Okay, or I buy. Okay, I buy sunglasses which offer UV protection, ultraviolet rays protection. But it turns out that the glasses are simple. They do not offer any ultraviolet protection. So now these sunglasses are not of merchantable quality. They are not of merchantable quality. Provided that further there is an exception to this rule. Proviso, whenever we say proviso or provided, it means an exception to the rule. That if this condition is there, then the rule shall not be applicable. Provided that if the buyer has examined the goods, there shall be no implied condition as regards defects which such examination ought to have revealed. Okay, obviously, if you could have examined the goods and upon the examination you would have found out those goods. Okay, you would have found out those goods, then there is no breach of condition in relation to that particular defect. But if the defect is hidden in such a manner that even upon careful inspection you cannot find out that defect, then there is definitely a liability of the seller and there is a breach of implied condition. The expression mercantile quality, though not defined, nevertheless connotes goods of such a quality and in such a condition. A man of ordinary prudence would accept them as goods of that description. It does not imply an illegal right or legal title to sell. Okay, we are not talking about here legal right to sell or legal title to sell. We are talking about generally goods should be which a normal ordinary person would buy them for. Okay, I buy a car, but turns out that car does not run at all. Car has flat tires. Okay, or car has no engine, or the car's engine is the engine of bike. He has put the engine of a motorcycle into an engine of car. Now that car becomes impractical, though it runs, but it doesn't run at all. Okay, it runs but doesn't run also. So this is an impractical combination. So goods are not mercantile quality when something like this is done. Or I want to buy a cup of cup for tea. I want to buy cups for serving tea, but the cups are of such a nature that when hot tea is poured into them, they crack out. So this is not a mercantile quality. This is not a quality which a person would expect from a cup meant for serving tea. Okay, because tea is obviously hot, and the cup should withstand the temperature of the tea, otherwise it is going to crack down. So what is the benefit of having such a cup? Example 1: if a person orders motor horns from a manufacturer of horns and the horns supplied are scratched and damaged. So I order horns from a horn supplier and the horns are scratched and damaged. Okay, owing to bad packaging, he is entitled to reject them as unmerchantable. I will not, nobody will definitely receive or accept scratched and damaged goods. They are not mercantile at all. They are not usable. They are not sellable. They can't be used. That's it. A bought a black velvet cloth from C and found it to be damaged by white ants. Held that condition as to mercantility was broken. Condition as to mercantility is broken. Condition as to wholesomeness. Now, the condition as to wholesomeness. In case of eatables and provisions, in addition to the implied condition as to mercantility, there is another implied condition that the goods shall be wholesome. Okay, goods should be wholesome. They should not only be consumable, but they should also have nutrition in them. Okay, it is in relation to consumables. I buy almonds. Okay, almonds are known for having omega 3 oil. Okay, now almonds are edible. The almonds are edible, they are delicious as well, they are tasty as well. But it turns out that by using some process, they have already juiced out, they have already taken out the oil out of the almond. Now it is this almond is only an almond for eating, but almond has no nutritious value. This can't be done. Okay, or okay, I buy milk. Okay, I buy milk. Then turns out that milk is edible. There's nothing wrong with the milk. But milk has no calcium. They have taken all the calcium out of the milk by using some industrial purpose. Or milk does not have nutrition, or milk does not have fat at all. Milk is supposed to have fat. I buy a full cream milk, but it does not have a cream. If I buy a skimmed milk, okay, double skimmed milk, then I will not expect the cream to be there. But if I buy a full cream milk, they cannot simply supply me a milk. That milk is tasty and edible, but it should also have cream, it should also have thickness. So that is the quality as to condition as to wholesomeness, that the goods should not only be consumable, but they should have nutrition as well. They should have nutrition as well. A supplied F with milk. The milk contained typhoid germs. F's wife consumed the milk and was infected and died. Held there was a breach of condition as to fitness, and A was liable to damage. Now we go to, from implied conditions we go to implied warranties. Just like implied conditions, we have implied warranties as well. It is a warranty which the law implies into the contract of sale. In other words, it is the stipulation which has not been included in the contract of sale in express words, but the law presumes that the parties have incorporated it into their contract. It will be interesting to know that implied warranties are read into every contract of sale unless they are expressly excluded by the express agreement of the parties. Okay, these may also be excluded by the course of dealings between the parties or by usage of trade. These implied warranties may be excluded by express agreement. Even implied conditions can be excluded by express agreement, but if there is no agreement, they will be read there. Same is the case with the implied warranty. If there is an express agreement to exclude implied warranty, it will be excluded, otherwise not. These may also be excluded by the conduct of the parties. Section 14 and 16 of the Sale of Goods Act discloses the following implied conditions. Now, following implied conditions are provided in the Act. Okay. First one is warranty as to undisturbed possession. Warranty as to undisturbed possession. An implied warranty that the buyer shall have and enjoy quiet possession of the goods. That is to say, if the buyer have got possession of the goods, is later on disturbed in his possession, he is entitled to sue the seller for breach of warranty. Okay, so when I have the goods, my possession of the goods, my control of the goods should not be disturbed. If my control of the goods is disturbed, it's a breach of warranty. It's a breach of warranty. Suppose goods are okay, goods are infringement of a trademark of a brand. Now brand has taken illegal action and the goods are confiscated, and my goods are also confiscated. So there is a disturbance with my possession. There is a disturbance with my possession, or someone has sold me a book. Okay, but author had not given the right to publish that book. So now the book is taken back from me. Author has taken a legal action and the book is taken back from me. Okay, this is a breach of implied condition, as well as it is a implied warranty as well. This is a breach of implied warranty as well. Warranty as to non-existence of encumbrances. Encumbrances means charge or charge or someone else's claim. Warranty as to non-existence of somebody else's claim, that no one else can claim it, okay, other than you. An implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, not declared or known to the buyer before or at the time of the contract is entered there too. It's an implied warranty that when a good is sold to me, the good should not have somebody else's charge over it. Like we discussed a case of Muthoot Finance. I go and pledge my gold with the Muthoot Finance, but meanwhile I am paying my installments, and meanwhile somehow Muthoot Finance has sold the gold to someone else. Okay, but now I have a charge over the gold. So Muthoot Finance cannot do so. A pledges his car with C for a loan of 15,000 rupees and promises him to give its possession the next day. A then sells the car immediately to B, who purchased it on good faith without knowing the fact. Okay. B may either ask A to clear the loan or himself may pay the money and then file a suit against A for recovery of the money from with interest. Okay. So now what has happened here? A pledges his car with C. A says, I'll give you my car, you give me a loan.
It's 5
And
o'clock.
he has now taken the loan, but he has sold the car as well. Okay, now what will happen here? Both the people will have a disturbed possession, C as well as B. They will keep on fighting for the car, and A is responsible for that. That is a breach of implied condition of non-existence of encumbrance because there is encumbrance over it. Okay, encumbrance of C exists. Warranty as to quality or fitness by usage of trade. Okay, usage of trade means whatever trade this particular thing is used in, for that trade it should be sufficient. Like a touring bike, it should be suitable for touring. It's just like breach of conditions, breach of warranties are just like similar. An implied warranty as to quality or fitness for a particular purpose may be annexed or attached by usage of trade. By usage of trade. Whatever is the usage of trade, okay. Racing car for racing, touring car for touring, sofa for sitting, phone for calling, etc. These are the uses of trade. Okay, so regarding implied condition or warranty as to the quality or fitness for any particular purpose of goods supplied, the rule is let the buyer be aware. Seller is under no duty to reveal unflattering truths about the good is sold, but this rule has certain exception. Okay, seller is under no duty, but it does not mean seller will hide each and every detail. Okay, seller can pass on a defective good to you, though the buyer is best choice maker. There are four cars known for their touring capacities. Now, one of them is good, one of them is all of them are good, but one of them is slightly less good than others. I buy that. That is my choice. That's it. Okay, I cannot run after the seller that he should have suggested me to buy another vehicle. It is not his duty. Disclosure of damage, dangerous nature of goods. Okay, disclosure of dangerous nature of goods. Some goods are dangerous in nature, like you must have seen on deodorants. Deodorants, it is written all out mosquito. Do not consume it. Is deodorants? It is mentioned inflammable. Something like this. Okay, these are mentioned. You must have seen these things that it is mentioned, or medicines. So these are the things written, these are the labelings, these are disclosure of the dangerous nature of goods. This is a disclosure of dangerous nature of good, okay? Where the goods are dangerous in nature and the buyer is ignorant of danger. The seller must warn the buyer of the probable danger. If there is a breach of warranty, the seller may be liable of damages. So tomorrow, if someone is selling a deodorant and not mentioning that it is inflammable, so if some fire is there, if the buyer is injured by fire due to the deodorant, then the merchant or the seller shall be liable if he had failed to disclose this on the good that it is inflammable, or even expiry dates of the products, expiry date of a product, expiry date of the product. These are the disclosure of dangerous nature of goods. Okay, so you have to keep in mind.